or self-interest groups going to seek pardon cannot be an interloper to decide the whole idea of pardon, Justice Kaju. I'm sure you'll agree with me that this particular citation I'm making is not out of context in the case of Sanjay Dutt. And I think Subramaniam Swamy wants to add something there. Yes.
Yeah, I want to add. See, the question is, Justice Kaju only talking on generalities. Why I asked him to name the a judgment, because he said that this one judgment doesn't make the law. Unfortunately, that's not the general opinion. It may, if he has a different opinion, he should tell me which judgment overrules this judgment. Number two, he uses the word humanitarian number of times. Now, fact of the matter is that most of the cases I have seen, unless he has seen some other case which is similar to Sanjay Dutt's, these cases are where a person has served for a long time and he's sick, he may die, and these are the cases where the humanitarian considerations have entered the picture. But even here, in the case of one rapist who killed a young girl from Calcutta, I forget the name of the case, but he had appealed after doing 20 years in jail, and he was quite sick, and he said, I don't want to leave the jail, but please don't execute me. And even that was not agreed to. There is no provision under the Article 72 or 161 for going into the judgment itself, whether the judgment was fair, not fair, and so on. The only consideration, according to the Supreme Court law, is that whether public good will be served or advanced, public welfare would be served, and also the victims also have to be taken into account. Here, whether unwittingly or wittingly, but with your eyes open, you engaged in an activity which was supplemental to a killing of 235 people and 700 people injured. They are victims, and their feelings also count, and that also is included in the Supreme Court for consideration when you think of a reprieve. And here is not for life. You're not executing him. It's only remaining 3.5 years. I can't see why he can't serve that sentence.
So basically your point to Justice Kaju, your turn to respond. What Subramaniam Swamy is telling you is two things, sir. It's an open and shut case. Also, may I please get your response to what the Supreme Court said, sir, Justice Kaju, while upholding the Tada Court judgment? It said, evidence and materials perused by the Tada Court in arriving at the decision against Dutt was correct. The circumstances and nature of the offence was so serious that Dutt could not be released on probation.
Now may I answer?
Sir.
So far as that first point Mr. Subramaniam Swamy raised, Nanawati's case is there. There was no public welfare in granting pardon to Nanawati. I can give you dozens, and if I had my library with me, I could have given dozens, but I'm not going to labor on that. Let me tell you one thing, that so far as Sanjay Dutt is concerned, now Mr. Subramaniam Swamy has said, what about 250 people who have been killed and all?
Yeah.
Now please consider, firstly, there's a categorical finding of the Supreme Court that Sanjay Dutt is not involved in those bomb blasts. Secondly, the only charge on which he has been convicted is having illegal weapons, for which Supreme Court in paragraph 70 has said that Sanjay Dutt had not kept these for terrorist activities but for self-protection. That is mentioned in paragraph 70. So what is this Mr. Subramaniam Swamy saying that he had a hand in killing 250 people and all that? The Supreme Court is saying he does not have a hand. Supreme Court has said that although he kept an illegal weapon, but that was not for terrorist activities but for self-protection. Now, on what basis is Mr. Subramaniam Swamy saying all this? I fail to understand. And so far as my plea for pardon is concerned, I have given you a large number of reasons on which cumulatively I am of the opinion that it is a fittest case for pardon. So therefore pardon should be granted.
Sir, may I ask you one thing?
Let me just make one point clear. I never said that Sanjay Dutt is directly responsible for this.
Go on, sir, go on. Please continue.
Can I go on?
Yeah, please continue. Sorry.
I never said that Sanjay Dutt is directly responsible for the Bombay explosion. I said that he was a cinema star, but he was engaged in all these criminals who are directly responsible. I think that it's also a question of creating circumstances in which these people can think that there can be normal, where a person who has a high reputation in the cinema world is seen consorting with them, not only before the blast but also much after the blast. And therefore, just because he has not been held directly responsible, I think the fact that he held weapons which a cinema star shouldn't be having. What is a cinema star doing with 2 AK-56 and so many guns and pistols and so on? These are circumstances which the judges have gone into, and they come to a decision. Now we can't review the decision in a pardon. They can go on a review or a curative petition, but they can't do it through the pardon. The pardon, the only consideration for which Mr. Kaju has not explained how it applies here, is whether public good would be served by letting Mr. Sanjay Dutt give up, be saved from the 3.5 years left of his sentence.
Now, Justice Kaju, want to respond? Because I have a follow-up last question to you, sir. Do you wish to respond? I think he's making a point of public good for a third time in the debate tonight between both of you gentlemen. Subramaniam Swamy is asking you the question of public good. Would you like to respond to him, or can I ask you one follow-up?
Yes, I have already said that humanitarian considerations are also consideration on which pardon can be granted. It is not that you construe public good in a very narrow sense, that some public welfare scheme will be set up or something. In the case of Nanawati, there was no public good in the narrow sense. He was released because of on humanitarian grounds that he had suffered so much and all that. But what I am saying is that in the case of Sanjay Dutt, there is a categorical finding of the Supreme Court that he is not a terrorist, not involved in the bomb blast, and that he had kept weapons for self-protection.
So do you keep an AK-56 for self-protection?
So therefore, although
may I ask you, sir, Justice Kaju, do you actually believe that anybody keeps AK-56
yes, I am answering you. I am answering you. I am answering you. Will you permit me to answer, Mr. Arnab Goswami? I am answering you. That is the finding of the Supreme Court in para 70. That is the finding of the Supreme Court in paragraph 70, that he kept the weapon for self-protection. You may say it is a wrong finding of Supreme Court. You may keep saying anything. Either you accept the Supreme Court or you don't accept the Supreme Court. If you don't accept the Supreme Court, then what is all this discussion about? I am saying go by the Supreme Court judgment. In paragraph 70, Supreme Court has said that he kept it for protection. Now, you can't challenge that verdict of the Supreme Court.
There is one question I have for you.
Statement you are making.
I have one question. I've been meaning to ask you this. You know, you've been quoting the Nanawati case. Now, for the viewers who are not aware of the Nanawati case, let me say this. What is the Nanawati case? In the year 1959, Kawaz Manekshaw Nanawati was a naval commander, I think, in Mumbai, tried for the murder of Prem Ahuja, his wife's lover. The High Court dismissed the acquittal and convicted the accused to life imprisonment. Now, why was Nanawati granted pardon, Justice Kaju? He was granted pardon because the person he killed, Prem Ahuja, his sister, Mami Ahuja, was persuaded to forgive Nanawati. She gave an assent for his pardon in writing, and within one day, Vijayalakshmi Pandit, I think, who was then governor of Maharashtra, gave pardon. So my question to you, Justice Kaju, is whether you say is directly linked or not. The fact is, this is part of the 1993 Mumbai blast case. This is not a case in which one person can come and say, give pardon. 198 people, if I am not mistaken, or more, died in the Mumbai blast. Will the families of 198 people be asked to give their point of view in writing on whether Sanjay Dutt deserves leniency? Do they not have a stake? Can they not be permitted to have a view on whether he deserves leniency?
Whom are you asking?
Sir, that question is to you, Justice Kaju. And if Subramaniam Swamy wants a comment, after you. Yes, Justice Kaju.
Yes, I do.
Yes, there was no public good in granting a pardon to Nanawati from the point of view which Mr. Subramaniam Swamy is making. Just because his sister of Ahuja makes a plea does not make it a public good, or sister of Ahuja says, I pardon you, does not make a public good. That is not the public good. here it was on humanitarian consideration because the man had suffered so much. See, the humanitarian consideration may not be relevant in judicial proceedings where the minimum sentence is prescribed, but they do come into play in pardon proceeding, because if you see Article 72 and 161, it does not say on what ground is the pardon to be granted.
Sir,
it is very widely worded that the president can grant pardon. It does not mention on what ground,
No, sir,
how much
Nanawati,
time it will take.
So I can equally, so if I may rebut, that, may I ask you, Nanawati was not granted pardon on basis of any humanitarian considerations. Nanawati was a politically connected man. He moved in high political circles. He managed to get the sister to write a letter saying forgive him, and the governor passed it. So Nanawati was not pardoned on humanitarian considerations.
All right. What was the public good in granting him pardon?
There was no public good, but there was no humanitarian consideration either.
Public good. Public good is, Arey Baba, I am telling you, Article 72 and Article 161 do not mention the grounds on which pardon should be granted. It is very widely framed. So there is very wide power to the president or governor to grant pardon. Okay. Of course, all power should not be used in a mala fide manner.
Yeah, okay.
This is the only restriction. No power should be used in a mala fide manner. Okay. As long as it is bona fide, it can be on humanitarian ground, it can be for public good, it can be because the sister has appealed, it can be various.
Whatever.
It should not be mala. That's all.
Okay, Dr. Subramaniam Swamy has a comment on your and my interpretation of Nanawati, of the Nanawati case.
Yeah. Well, first of all, you see, Nanawati's case 59, and it's due to a series of misuse of this pardon that the 2006 judgment was a decisive judgment to lay down the law. In fact, in Tamil Nadu, for very often every year on the birthday of Annadurai, they would release hardened criminals as a birthday gift for Annadurai. And same thing happened in Andhra Pradesh when YSR Reddy released about 1,600 people on somebody else's birthday, whose name I'm going to take here. Now, therefore, somebody went in appeal, and then it came all the way to Supreme Court, and the law laid down is the latest. Why I keep saying is that Justice Karju must mention which judgment he is relying on, where he talks about this humanitarian applying to everybody. I know that humanitarian cases can be for people who are going to die or very aged, have served most of their sentence, etc. But here, for the kind of case for which Sanjay Dutt is been convicted, I don't see any judgment which fits it. And he remembers Nanawati, but he doesn't remember any other judgment. And yet he says that he knows more law than anybody else. Now that is something which I have never questioned that. I have always considered him a great scholar in the field of law. But the fact is that here we have to go by objective standards. And even if 72 and 161 of the Constitution does not put any limits on the power of the President, Supreme Court judgments have interpreted on judicial review that these are the parameters within which the decision must be taken, and none of them apply to Mr. Sanjay Dutt.
Now, I want to say one thing. Justice Karju said twice tonight that if you were raising that point, he says he can point out enough judgments to contradict you. And I'm sure he will. No, I'm sure he will. What I'm going to do is, I'm going to perhaps take this discussion forward, because I think we've had a proper legal debate for some time, after some time on the Newshour Tonight on this subject. I stand corrected, Justice Karju, not 198 but 257 people died in the 1993 Mumbai blast. I said something wrong there. But gentlemen, you've presented 2 points of view. I can say this, no two better equipped and aware and erudite people could have debated the legal contours of the Sanjay Dutt controversy than Subramaniam Swamy and Justice Markanday Karju tonight. So tonight only, I'm closing this with a promise to come back to this debate. Justice Karju, would you like to say something to Subramaniam Swamy? Because I can clearly see here, he makes the point to you 3 times tonight. He almost seems to be challenging you to another Newshour debate. Would you like to say something to him?
Mr. Subramaniam Swamy has practically conceded that humanitarian consideration is also consideration, but he says it should not apply in Sanjay Dutt's case. Perhaps he was referring to Zaibun Nisa's case. So therefore, in a sense, he is conceding that that is also one of the considerations, because as I said, Article 72 and Article 161 do not mention on what grounds it should be.
Okay.
It should not be mala fide. It should not be wholly arbitrary.
Yes.
Something
Gentlemen.
ridiculous. Otherwise, there is very wide power, humanitarian consideration, public good, public welfare, various considerations. It's not limited to public good as if Mr. Subramaniam Swamy is trying to say.
Well, I can only say this, the judge has the last word. Justice Markanday Kachchu and Subramaniam Swamy, thank you very much for joining me on debate number 1 on the Newshour tonight.